and welcome to the webinar, BJA Technical Assistance Webinar Series, Budget Advocacy in the 21st Century. This is the second of a three-part series on budget advocacy, and this session is entitled Data Collection and Analysis for Budget Advocacy. Today we have with us two presenters, Thomas Maher, who is the Executive Director of the North Carolina Indigent Defense Services, and Jeff Burkhart, who is an attorney and project manager at the American Bar Association. And they have come to talk about the topic that we're highlighting today. The topics are related to the survey that many of you participated in back in the summer of 2014. The American University and NLADA sent out a survey on the 10 principles of a public defense delivery system. And the questions were designed to ask about not only your awareness of the principles, but also if you needed any assistance in better adhering to the principles. And the response that we received overwhelmingly showed that offices wanted more information about budget advocacy. And they also wanted more information about not just the collection and analysis of data, but then how to use that data and analysis to meet their goals, in particular with regard to funding. And so we designed this series to address those concerns. The first part of the three-part series addressed cultivating relationships. This one's on data collection and analysis, and the third one, which will be on July 30th, addresses the issue of how to then use that data and analysis to advocate for your increased budget. So today's topic on data analysis will address several of the 10 principles that you had questions about. Of course, the advocacy for independence, that's certainly a goal that many of you have, and data can certainly help in that effort. And then also in analysis of caseloads and workloads, principles 2 and 5, you'll be able to better discern what those loads actually are after collecting that information. Another principle that I think is very interesting to measure is the defense counsel's ability, training, and experience, and whether that matches the complexity of the case. You can really go deep in data and do an analysis of that to determine how much more professional development your attorneys may need as a result of that. And that also relates to Principle 10, which is, which goes to the supervision of your staff for quality and efficiency of the service that they provide to your defender client. And, in going back to that topic that most of us focused on with the survey is on budget. And so data collection certainly helps with Principle 8 in terms of parity between defense counsel and prosecution with respect to resources. And so we hope to be able to provide some information that you'll be able to use to increase those resources. So the three-part series, again, is offered by American University and NLADA, and these webinars and the information provided with the webinars will be archived and found on American University's website. It is www.righttocounsel.ta.org, and that information is also found. You'll see that further along during this webinar. So without further ado, let's get into some of the questions that we hope to answer with this webinar. What data should you collect for purposes of budget advocacy, and how should you collect this data, and how can you creatively use the data you're already collecting in support of your budget initiative? We have with us two experts in data collection and analysis. One, a defender chief, another an attorney and expert in data collection and analysis projects, and he'll be able to break that down for you during his presentation. We'll start with Tom Maher, Executive Director of North Carolina Office of Indigent Defense Services, and I think that he has much enlightening information that will help offices, especially offices that are just starting down this road of data collection and analysis. Tom, I will turn it over to you.
Thank you. Okay, I hope everybody can hear me, and welcome, and thanks for spending the afternoon. As Michelle said, I am Tom Maher. I'm the Director of the North Carolina Office of Indigent Defense Services. We are a statewide agency responsible for public defenders, private lawyers throughout the state of North Carolina. And today I'm going to talk about basically three things. I'm going to talk about the history of North Carolina's development of using data. I'm going to talk some about the lessons I've learned from our use of data, and then I'm going to spend some time talking to a recent example of using data as a campaign for funding. In this case, the campaign was restore funding for the private assigned counsel. In North Carolina, our history, I guess, can be summarized that we started before IDS in what I view as a primordial soup. We were created in 2000. And began operations in 2001, and now as an agency we actually have a fairly robust ability to use data. We have a research department. We work on what we call the Systems Evaluation Project. We produce reports. And one of the things that I've learned since I've been here, and I've been here 6 years, is the importance of data both in terms of management but also advocacy. Okay, so back before IDS, North Carolina's indigent defense system was run through our administrative office of the courts, and there was no centralized management, there was no real oversight. Basically, judges appointed lawyers, and they were allowed to pay whatever they wanted to on an hourly basis, and everything was basically counted by the number of case files closed each year. So there was no effort to look at cases in any systematic fashion. There was no ability to figure out where the money was really going, let alone what was happening to the clients in the system. In 2000, IDS was created, and fortunately, the creators recognized that having reliable statistical information was an important part of indigent defense, and so that's part of our statutory mission. We've actually got a research department. I put department in quotes because some of you might know her as Margaret Gressens, if you've spoken to her, or John King, her assistant. So it's a two-person department, but they are focused on meeting our research needs. And we've been able to do a lot of things. We have, for example, begun working on what we call the Systems Evaluation Project, which is not just about how much you spend or how many cases do you resolve, but what's actually happening in the system. And the notion, which you could spend a whole day on, is identifying the goals and objectives of the system, and then identifying concrete indicators that you can measure to see if you're achieving those goals. And we've been able to make a fair amount of progress on that. So now at IDS, basically we routinely use data to analyze issues. We're able, for example, we did a report on the outcomes in potentially capital cases. We were able to look at the fact that in most cases, the difference between a case that proceeds capitally and a case that does not proceed capitally is the cost. It costs about 3 times as much, and for the most part, the outcomes are about the same. And so there was a powerful message there about district attorneys basically driving costs by their decision to charge a case capitally. We have a few counties that pay flat fees per case in lower level cases. They've been doing that historically. It allows us to look at the outcomes in those cases and see what we viewed as a very concerning trend, that the outcomes in those counties were not as good for clients as in counties that had lawyers who were paid by the hour. And of course, that relates to the whole notion of pushing lawyers to resolve cases too quickly. And thanks to work with the NLADA and an Open Society Foundation grant, as I said, we've been working on this systems evaluation project and been able to work with several other jurisdictions and starting to really develop the indicators that measure the outcomes in the cases. So I've been fortunate to work in an environment where research is kind of a given, and it's really been very useful. I will say that my background is not in research. I was a trial lawyer. I loved being in court. For me, evidence was evidence about a specific client. It was not kind of data research evidence, and so coming here, it took me a while to learn the importance of it, and I've been here long enough, I think, that I understand it now. And one of the things, you know, for us, and I think most people running an office, they're really, you think about why data matters. And I would say, you know, not to say first and foremost, but of some importance is funders. You know, we all get funded somehow. In our case, it's the state legislature, the General Assembly that decides how much money we get and to a certain extent dictates how we spend it. And their basic question is, where's the money going? You know, what are we getting for what we're spending? But people who run their office also matter. You know, if you're running an office or supervising an office, data matters to you because you want to know how the system is operating in your office. You know, if you spend time with data, it can become a useful management tool. We had a chief public defender in one of our larger offices who actually reduced caseloads for people handling certain felonies and looked at it and tracked it and realized that they were actually able to dispose of more cases because they spent less time juggling too many cases. So there was a useful example of actually looking at the data and recognizing that reducing the current workload might increase their productivity while helping the clients. And then, of course, ultimately the reason we do any of this is for clients. You know, the main goal we have in the systems evaluation project is to identify indicators that tell us that the clients are achieving or we're achieving for the clients the objectives and goals we want to achieve. And data really helps you understand that in something other than kind of a anecdotal way. Now, as I said, I have not spent my time as a researcher. I came into this without a research background, and maybe that makes it useful for me to share some of the lessons I've learned as a non-research person about data and the benefits and pitfalls. One of the things I've learned is to not reinvent the wheel. You know, we are in an age where there's a lot of research being done out there. I think in indigent defense there's more being done than there would have been 10 or 15 years ago. There's a fair amount of available research and data. So before you take off on a project on your own, I would strongly suggest you look at what's already out there. We're currently in a very tough legislative session. There are concerns about how we handle capital cases. We have a capital defender's office that covers cases in various counties, you know, with full-time attorneys, and there's concerns about that. And quite frankly, even with our research capability, we can't kind of do a cost-effective or quality analysis for an entire office. But, you know, going on to the web, I was able to very quickly find that in Texas, they had a regional public defender. It operates very much the way ours does. They had done a study that showed both quality and cost-effectiveness. And while it wasn't perfectly tuned to North Carolina, it was a useful tool in terms of educating both ourselves about how to do a study and responding to at least some legislative concerns about a capital defender's office. And all it took was a Google search. There are, some of you know, reports out there. Texas, once again, has some. I think Minnesota may have some about caseloads. You know, one of the things I always hear when I'm talking to legislators is we need to be more efficient. Well, you know, I know the hours our people spend on cases, at least for private assigned counsel, and one of the things in looking at that and then looking at studies like this is the reality is we're too efficient. You know, if you look at some of the research that's been done, you know, we've kind of gotten used to very low hours on cases, and the research is very powerful in helping us understand that maybe we're spending too little time and what we need is more resources. Once again, we didn't have to do that study. There are studies out there about compensation for public defenders and district attorneys that help show for us where we fit in the scheme, but also the value of paying people well enough to stick around so you don't lose people that you've trained and invested in and have developed skills. So the first thing I would say, even if you've got a research department, is don't reinvent the wheel. Discover existing data before you start collecting data. You know, I think most, if not, I would assume at this point, all court systems collect data, and you should educate yourself about that data. We have a system that we call ACES. It's a combined infraction and criminal information system that the clerks put in. And there is a huge wealth of data in there if you learn how to read it. And, you know, the simple thing is to get yourself educated the way the clerks are. Get their manual. You can go to their training, find out how they're putting data in, what it means, and what's available. And I think learning what it means is crucial. For example, in North Carolina, case files do not equate to a case. We define cases by all charges that are disposed of at the same time in front of the same judge, but the court system doesn't group them that way. So when you look at their numbers, they're very different from our numbers, and you need to understand why that's true. If you're looking at, for example, number of clients who get active sentences, for us, all sentences that involve any active time are lumped together, but a significant number of those, as we've looked into, are time-served sentences. And a time-served plea presents real issues, but it's a different issue than somebody being sentenced to go into prison. So you have to understand what's there, and then I think you can find that there's a lot of data already available. Analyzing data. I spend more time than I ever thought I would in law school looking at spreadsheets and analyzing data. And one of the things, of course, you're looking for is trends. Are caseloads going up? Are other, you know, are active sentences going up or down? And it's very important to spend some time understanding what happens in trends, because they can be misleading. You know, a change in procedure or even in staffing can change disposition trends, particularly in small jurisdictions. North Carolina, we have 100 counties. Some are large, like Mecklenburg, where Charlotte is. Some are so small they hold Superior Court 4 times a year. And you have to understand kind of the law of small numbers. So, for example, several years ago, North Carolina started allowing prosecutors to appeal a suppression motion when a district court, which is our low-level court, grants a suppression order. Well, that adds a lot of time and delay to a driving while impaired case, and it may explain when you see trends of caseloads going up or cases aging differently that without knowing the change in the law, you wouldn't understand. It's also true that, particularly in small jurisdictions, a change in staffing can cause a trend. I remember going to a modestly sized county where we were working with contracts, and I'd noticed that the caseloads seemed to have spiked, a huge increase in the disposition. So I asked the local lawyers, you know, why has this gone up? Well, it turned out the answer was 2 fairly elderly assistant DAs retired. They hadn't been working very hard, and a whole bunch of cases that had been kind of sitting around suddenly got disposed. So the trend was very misleading if you were to predict that in the future there'd be more cases. It really was the result of a few individuals. So look behind the trends. Collecting new data. I will say we have, as I said, a research department, and they would love to collect more and more data. There's no such thing as too much data for them. But of course, if you are a defender, you have other things to do than report data. So when you're going to ask people in the defense community to collect new data, understand that that's a time commitment. That's using their resources. And you know, our kind of mantra is collect what you need, which may be less than you want. I mean, kind of think through what do you really need them to do, because you're asking them to take on a burden. Educate them about the importance of the data. We, for example, would love to have our assistant public defenders collect hours. They don't like doing that, but there's a real value in being able to show that the amount of resources needed for the work, and if you don't record the hours or you don't record all your hours, you end up undermining the claim that you need more resources. So you have to educate them about why taking the time to record this data will help them in the long run and help the system in the long run. And then I personally think you need to use what you collect. Because if you're going to ask people to take the time and then you end up not using it or not letting them know how you use it, you kind of undermine your ability going forward in the future. We had, when I first came here, started asking lawyers who were the private lawyers when they filled out a fee application to put down the date of their first interview with the client, because we wanted to be able to check and make sure people were seeing their in-custody clients. The truth is we haven't used that as well as we could have, and I think it probably makes it harder for us to go back to them and ask them to provide us additional data. Presenting data, and I think this is really important. I cannot express to you how important it is that simple is better than complex, even if it does not paint the whole picture. I spend a significant amount of time trying to understand the nuances of data, different case types, why a trend may or may not be a trend, things of that nature. And so, for example, I tend to look at things like this, very complex spreadsheets. If you go to a legislature with that, they're not going to get anything from that. What you really need is a very simple presentation. Pie charts work very well. I recently put together a whole notebook for a legislature, and the only thing he was interested in was some maps that I'd hand-colored showing counties we'd covered. So think hard about what the kind of essential narrative or story from your data and how to present it in a way that somebody who's not steeped in all the nuances, who doesn't have the time you have, and who has to juggle a lot of other issues is going to understand it, and run it by other people. Make sure that somebody who hasn't put together the data the way you have understands the narrative that you're telling, because otherwise all your hard work really doesn't go very far. Okay, I'm going to talk some now about advocating using data for increased PAC rates. And for us, PAC means the private assigned counsel. As I said, North Carolina has a statewide system. We have public defenders that cover about a third of the counties, and even in those counties, their conflicts are covered by private lawyers. And in the remaining counties, all the work is done by private lawyers. And up until recently, most of them were paid by the hour. They'd be assigned a case and they'd be paid an hourly rate. And we were fortunate that our hourly rates were fairly, I guess, healthy compared to most. We were paying $75 an hour in state court for non-capital work and $95 for capital. Bad times came, a much more conservative legislature came, and in 2011 we had to reduce the rates for our private assigned counsel. And so we've gone from a system where about 2/3 of the work was done by people who were paid an hourly rate that would cover overhead and encourage them to do the work, to a system where they were losing as much as $20 an hour from what they were being paid, which is very difficult because their overhead hadn't gone down, their costs hadn't gone down. That was coming straight off of their ability to pay themselves. And so we've been working on a message to restore those rates. And the message was that those rates were not sustainable. We knew we had a legislature that wasn't going to pay lawyers what they're worth just out of a desire to be good to lawyers, that they had to understand that the system as a whole required healthy rates, and that if they didn't restore them, the system would not work. And we also made it clear that we weren't asking for what we viewed as raising the rates, but as restoring them, and language can be very important as you advocate on budget matters. So we started off, as I said, looking for our available data. And in our situation, as we get fee applications, they're entered into our financial system and checks are cut, so we know the names of lawyers and the number of fee applications they're doing each year. And we were able to look at the rate at which lawyers who had been doing work stopped taking cases because their names disappeared. We would end up seeing that they were no longer doing fee applications. And of course, that happens every year. People retire, they take a different job, they move. But we could look at the rate. And all things being equal, you would expect the rate to stay the same. And so we were able to analyze, going through all of our data to see which attorneys were no longer taking cases, and analyze that the rate of people dropping off the list was in fact increasing. And in fact, it was increasing a fair amount. And when we went to our courts commission recently, and this is a slide we presented, we were able to show that the rate of people leaving had increased between 1/3 and 50%. And so if we were losing 100 lawyers a year in the past, now we were losing 130 or 150. So this was kind of available quantitative data we had, but by itself it wasn't going to be enough. So we then moved on to collecting some additional data, and we did it through SurveyMonkey, which you don't have to be a brilliant researcher to use SurveyMonkey. You don't have to have a lot of money. You do have to give some thought to it. And what we tried to do was to collect both quantitative data on the impact of the rate cuts on attorneys and their clients, because ultimately this is about the clients. But we also wanted some qualitative data. So on quantitative, we were looking at number of attorneys who were losing support staff or reducing their indigent caseloads. On attorneys who believed that quality had declined due to the loss of experienced attorneys. And then we wanted qualitative data on the impact. And by qualitative data, I basically mean stories, narratives, because hard data by itself, in my view, is really important. It's hard to get anywhere without it, but you also need a story to go with it to make people care about it and put it in context. So we did this survey. We had about 400 of our attorneys respond, which is a very high response rate, and we were able to produce a report which we distributed, and I've got just a couple pages here to show, for example, we had pages about the rate at which people are dropping off of the rosters or planning to, losing support staff so that they had less resources to provide representation, the number of attorneys who believed, just watching on a daily basis, that quality had gone down. That was about 80%. And we were able to put this together. And we also asked the attorneys to basically give us quotes or stories about the impact on them, the impact on other attorneys in their districts, and the impact on their clients, and the importance of what we do for our clients. So, and we were able to get some good quotes. Here, for example, an attorney talking about, the clients who are facing financial distress, homelessness, lack of resources, and all the things that our client base faces, and that the importance of effective representation. Because ultimately, if your funders don't care at least some level about the quality of what you do and about your clients, they're not going to care as much about whether the system works. So we were able to put this report together. We have this report. Anybody who goes to our website can see it. And we wrote it in a way that it's got a lot of data, a lot of charts, a lot of pie charts, but also quotes and stories so that it would appeal to both the kind of quantitative side and the qualitative side. We were able to send it to all legislatures and make a presentation to our Courts Commission, which is a commission that meets when the General Assembly is not in session, and had a presentation on this. They were issued a report with a number of recommendations, and fortunately for us, one of the recommendations is that they should provide increased funding for the rates paid by us for our private counsel. Now, we haven't gotten it yet. We're still in the legislative session. There's always a lot of people asking for money, but it certainly gave us some traction with them, and it was, I think, the combination of hard data and some actual narrative to go with it. So, in closing, I'd share, I guess, a few more lessons that I've learned through all this. One is that it's a lot easier to collect data if the participants see a value. Our lawyers on this particular survey saw the value. They knew we were using this to advocate for resources they needed, so we didn't have to convince them to do that. That will not always be true if you don't spend some time to educate people. So you want enough people to spend enough time providing you data. You need to kind of sell them on why it matters. The results you get are not always going to be simple. We looked at this and we saw that some people said we're losing lawyers, and some said, well, there's too many lawyers. We have these for-profit law schools. There's many young lawyers out there. So you had to kind of analyze it carefully. And in our case, I think what we learned is that we were losing experienced attorneys and being replaced by far too many attorneys without experience who weren't getting enough cases to make a living, and that the story, while more complex, still was a story of a real threat to indigent defense. The other thing I learned, and this can be painful, is that when you've got a mixed delivery system and you are speaking for the entire delivery system, when you advocate for one aspect, you're going to bother people in the others. And we were doing a very forceful job of advocating for the private assigned counsel. We had tried to educate the public defenders that this was something that benefited everybody, that a public defender system shouldn't be compared to an overly cheap private system, that the clients needed to benefit from this. But even with that, we got a fair amount of pushback from some of the public defenders about the fact we were advocating for the private bar. And that's just a reality that people tend to view the world through the work they specifically do, and you need to be aware of that when you're advocating for part of the system and not necessarily for the whole system. So we've had a lot of complaints on that. We've tried dealing with that. In closing, I will say, that data can be a powerful component of efforts. In fact, I spend a lot of time in the legislature. I spend a lot of time answering questions. I brainstorm ahead of time, just like I'm preparing an oral argument, because you are in a sense. And if you can't answer data questions, you end up undercutting your effectiveness. And so it's not just affirmatively making the story, it's being prepared to respond when questions come up. A lot of that data is out there. You don't necessarily have to start from scratch. It takes time to read it. Quite often the data is complex, and you've got to spend a fair amount of time to think about how to put it into a simple, believable, and non-misleading story. And then ultimately, once you've done all that, you have to spend some time kind of pairing it with powerful stories to really get anywhere with an advocacy campaign. The data is crucial, but by itself, it doesn't really tell the complete story. Thank you.
Thank you very much, Tom. And that old adage, never a stat without a story, never a story without a stat, certainly does hold true in terms of effective advocacy using data. And I do have a couple of questions for you, if you don't mind. You have a research department in North Carolina Indigent Defense Services. Did that research department start with the office itself, or was that something that you had to advocate for?
That started with the office, and I think we were fortunate that when IDS was created, the legislature and those who were advocating for it had a fair amount of knowledge about what a good indigent defense system should look like and had support, so that part of the mission was to do this kind of research. And Margaret, who is our researcher, was hired very early on in the process. So that was kind of a given when IDS was created. It was something that was built into us. We had a study commission. The report's on our website. It talks about the reasons to have an independent agency, and data was one of them. Because quite frankly, the administrative, the office or the courts had not really used or collected data, and the result was they didn't manage indigent defense in a way that satisfied anybody.
Yeah. So even though you do have this research department, you're pretty savvy in research as well. And although your background didn't lend itself to that initially. So was it a very steep learning curve for you in terms of being able to look at data and analyze data to use it towards your ends?
I'd like to say no, it was all easy, but it wasn't. And I will say one of the benefits of having Margaret here is that I spent time with her. When she would produce a report or a spreadsheet or analysis, I would sit down and have her walk me through it so that I understood what they were doing, what it meant, what the question actually was that was being answered, and what the answer was. Once you've done that a number of times, you start to understand kind of, okay, what data really means and what it doesn't mean. I've also been fortunate, Margaret, with NLADA's assistance, has been working with other jurisdictions, and I've sat into meetings. And one thing you learn is kind of the differences in systems and how important it is to understand that. We criminalize a huge amount of conduct in North Carolina, and it means a lot of charges get dismissed. So it looks like we're winning a lot of cases. Well, those cases are cases that might not be brought, say, in Texas or Tennessee. So you end up learning by doing it. I find it very rewarding. It's not just interesting, but helps me understand the system better, and I think do a better job. But I've had to make the time to kind of let myself get educated. It doesn't just come instinctively.
So for those of us who are not as fortunate to have a Margaret present in their office to help walk them through it, do you have any suggestions for folks to find some expert assistance to help them with that walkthrough a few times?
Yeah, I think there's a number of places you can turn. If you've got local colleges or universities, there's often research departments, professors who are actually interested in what we do, who would probably spend time with you, educating you. Sometimes you just find there's somebody in your office, and maybe a support staff member who knows the case management system well, who can help you design queries. We do our capital and appellate assignments and fees in-house. We have an access database, and I've had people help me build queries so I can, on an ongoing basis get data. Don't overlook the support staff who put the data into your system. They may actually understand it a whole lot better than the lawyers who are reading it.
One more question. You talked about the existing data that people already have, and my question to you is, how difficult or easy was it for you to get that data from other stakeholders like courts or prosecutors or law enforcement?
Yeah, it ranges. For example, for us, and I imagine this is true in a lot of states, the court systems generate reports all the time that you can just go on the website and find. So if I wanted to see were case dispositions slowing or going faster, caseloads going up or down, I just went to existing reports. I didn't have to ask. For the kind of large data that we often work with from our court system, first of all, you need someone like Margaret to do it, and then you do have to kind of negotiate with whoever has the data, the format you're going to get it in, but it's all public data, and generally you're going to get it. I think the one time we ran into a problem was we were trying to get data from our DMV to look at driving while licensed revoked cases, and they wanted money, and one thing we don't have is much money, so that was the one time we haven't been able to get it. But you have to understand kind of how much you're getting and how you're going to use it, and we're lucky that we actually have like a data warehouse where we can do that.
Great, wonderful. And you know how much I love the Private Assigned Counsel survey report, and I strongly suggest to those who are tuned in to check out that report. I believe we can probably put up a link on the Right to Counsel TA website as well. It's a great example of using relatively, low cost or free service in SurveyMonkey, but turning that data and information into a very, very professional and very persuasive piece. So thank you very much for that. Now we're going to switch to Jeffrey Burkhart, the attorney and project director at the American Bar Association. Jeff has been involved in some really exciting workload projects, and a big component, if not the component of the workload projects, of course, is collecting and analyzing data to produce those reports. Jeffrey Burkhart, I will turn it over to you now.
Great, thanks, Michelle. So I want to pick up with something that Tom mentioned, that in a lot of cases we're too efficient. And that's a problem in a lot of public defender offices where people have prized efficiency over effectiveness for quite a long time. While you have the number of attorneys in a lot of offices staying pretty steady, the cases have gone up and up and up over the years. So the effect of that a lot of times is systemic ineffectiveness. You can't possibly represent hundreds and hundreds of clients effectively. So that's where the workload studies come in. So in the United States, there are more than 15,000 public defenders. So that number is based on a study by the Bureau of Justice Statistics back in 2007. So the data is kind of old at this point, speaking of data. We should have a new study fairly soon, and a better picture, actually, thanks in part to NLADA, of what that looks like. But that's roughly the number of public defenders we have in the United States. Now, those defenders handle over 5.5 million cases each year. So again, that's based on the Bureau of Justice Statistics numbers, so quite a number of cases. And there's some quick and dirty math that basically averages out to about 360 cases per attorney. Again, it's very quick and dirty math, and that's a little bit older data at this point. And we have a little bit of anecdotal data, though, that in a lot of jurisdictions that number is much, let me go back. In a lot of jurisdictions, that number is much higher. If you look at Rhode Island, and this is based on Norm Lefstein's book, Securing Reasonable Caseloads, in Rhode Island, the average attorney was handling a mix of felony and misdemeanor cases, 1,756 cases a year. So, and that's not a typo, 1,756 cases a year. When you think about that number, try to imagine what kind of client communication you could do in that amount of time. What kind of legal research could you do in that amount of time with that many cases? What kind of factual investigation could you do? What kind of sentencing investigation could you possibly do? Really, you get to a system where you get a lot of meat and pleats just by default. So it doesn't have to do with any individual attorney. It doesn't matter how good of an attorney you are. When you have that many cases, when you're saddled with that kind of caseload, you just can't be effective. So we know the causes of these types of caseloads, these enormous caseloads that are so common in public defender systems. One is inadequate funding, and I don't think that needs much explanation. Chronically, and this has been the case since not too long after Gideon, public defender offices have been inadequately funded. Lack of independence is the other, and this is the first of the 10 principles. A lot of times you have judicial or political interference of some sort that kind of binds the hands of public defenders, that ties your hands in terms of regulating your caseload, among other things. One of the other things that affects your caseload is the lack of control. So you don't control intake as a public defender usually. The prosecution, on the other hand, they can kind of turn that valve on or off, take more cases or fewer cases, and they can actually not just determine the number of cases, but also how big that case is. They control the way that they actually charge. So what is the solution to all this? Well, the best solution we've found so far is workload studies. And that's what I'm going to talk about today, are these workload studies. Here's, oh, sorry, I hear a train. I hope you can hear me over that. The first one, then workload studies have been going on for quite a while, but the ones we started to do that are a little bit more modern, they're slightly different than ones you may have heard of that were done previously by, say, the Spangenberg Group or the National Center for State Courts. So today I want to try to demystify workload studies just a bit. Now, the workload studies that we're doing have two parts. The first is a time study, and really the time study is just a way to figure out what's going on the ground. During the time study, we have public defenders track their time in fractions of an hour. And it's somewhat comparable to what attorneys have been doing for decades in the private practice. So again, the time study, when you think of time study, think of just what's actually happening on the ground. The second part is the Delphi process, and that is what should be. In other words, what are our workload standards? How much time should attorneys be putting into cases in order to be reasonably effective? So if you have attorneys putting in very little time because of very large caseloads, that'll show up in the time study. And if you have many more hours that should be put in order to be reasonably effective, that's what you're going to find in the Delphi process. You really need both. You need what's going on right now and what should be in order to show that gap. So I'm going to start with the time study. The time study, we have attorneys track along kind of two axes. One is the case type. And case type is exactly what it sounds like. It could be homicide, it could be sex offenses, it could be misdemeanors. Depending on the states, here in Illinois, we have Class 1, 2, 3, 4, and Class X. So it could be divided along those. Other states have A, B, C, D. Other states still, like Louisiana, I know they don't have any kind of strict classification system in that sense, but you can divide it according to, kind of roughly in terms of sentencing ranges. But in any case, what we want to do with the case type is figure out some kind of proxy for difficulty. We know that some felonies may be, or generally felonies are going to be more difficult than misdemeanors. We know that there may be an individual misdemeanor that takes a considerable amount of time. It may be more so than in some felonies. But generally, we want to have some sort of proxy for difficulty, and these tend to be pretty good stand-ins. Generally, your homicide is going to be a little bit more difficult, a little bit more time-consuming than your sex offense. Generally, a sex offense will be a little bit more time-consuming than a low-level felony, and so on. So those are the case types. The case tasks are also, I think, fairly common sense. What are you doing? That's basically it. Is it discovery? Are you spending time in court? Is it client communication? Is it legal research? So we want to capture data along both of those axes, right? So are you in a homicide case? And if you're in that homicide case, what are you doing? Are you doing something with discovery right now? So we want to track that. If you're in a misdemeanor case and you're doing client communication, we want to track that. So breaking those down a little bit more, when we did the Missouri study, which we're kind of replicating right now with some refinements both in Rhode Island and Tennessee, in Missouri we had 8 case types. And again, it's really just kind of proxies for difficulty, right? So we have murder cases, sex felonies, AB felonies, CD felonies, misdemeanors, and then after that, juvenile, and then probation violation, and appeals and post-conviction. This is going to vary a little bit, and again, we're working in Tennessee and Rhode Island right now, and they do vary a little bit. I believe in Tennessee we're looking at roughly 12 case types, same thing for Rhode Island, so a little bit more than what we had in Missouri. But in any case, generally you're going to have something that looks something like this. It'll be fairly similar. You're going to have probably murder cases and they're a separate case type. Sex offenses, we divided out in Missouri because they tend to be a kind of a strange animal in terms of the amount of research that's involved and forensic and things like that. And then after that, you break it down further to either Class 1 and 2, Class 3 and 4, or here in Missouri it was A, B, C, D. And eventually, once you get past misdemeanors, you have kind of an assortment of just kind of other things will pop up in your caseload. So juvenile cases take a slightly different amount of time than other cases. Probation violation, appeals and post-conviction petitions. Also, in other cases, other states, if you have abuse and neglect cases or something that are kind of slightly different that you wouldn't handle in your normal criminal kind of breakdown. So in Missouri, we stuck with 8 case types. Now, could you do more? Yeah, you could really fine-tune this and break it down to, here in Illinois, we could probably do 100 different case types. The problem is, at the end of the day, you wouldn't have a lot of data, right? I mean, how many times is fishing without a license really come up, you know? You might have one case that comes up every 20 years or something like that. You just wouldn't get a lot of data on it. So at the end of the day, we want a lot of data points on this. So now moving over to the case tasks, they broke it down to, we stuck with 14 case tasks in Missouri. And again, this will vary slightly depending on what you're doing in your office. So in Rhode Island right now, we're looking at about 12 case tasks. In Tennessee, I believe it was 13, but it'll be somewhere in this realm. And again, this is just trying to show exactly what you're doing. Now, could you break this down even more? Absolutely. You could really fine-tune this and have 1,000 different case tasks if you really wanted to. Again, we want enough data, though, at the end of the day to show what's going on. So there's a little bit of a balance that's taking place here. Now, there are three things that timekeeping requires. People, so you need attorneys tracking their time. You need clerical staff who, especially if you have attorneys who are not so technologically savvy. You need clerical staff and IT folks who can work with them a little bit to kind of get up to speed. Hardware, and again, this is just computers, tablets, and phones. And then software, and I want to focus on software a little bit more because I think people and hardware is fairly self-explanatory. The software, a lot of people aren't familiar with what kind of software you really need in order to track time. So what software should you use? Well, there are kind of two different ways to go here. A lot of folks will use commercial software systems. There are two that tend to be pretty popular among public defenders. A lot of folks will use Defender Data, which is used by, or created by JusticeWorks. Defender Data is used in parts of Texas. It's used throughout the federal system, so all federal defenders are using that right now. It's used in parts of California and Utah. So it's fairly common. One of their competitors is Justware. They also have time tracking software. So if you're fortunate enough to already have one of these systems, you likely have some sort of time tracking already built into your system. You want to talk to the folks with that software provider and ask them about not just turning it on, but how do you tweak it? They can give you something that's sort of prefabbed, but you might want to be able to tweak it in order to do a workload study. The other thing you can go with is kind of a more homegrown system, and we're used to working with these. With our Missouri project, Missouri had their own system that they built in-house, and they had a very good IT staff to help build it. Same thing with Rhode Island. There's a guy named Dan Bright in the Rhode Island office who built their system. It's very good. And same thing with Nashville. They have some folks in Nashville who built their own system. Knoxville, again, actually, we're working in Knoxville as well. They are using Defender Data. So we do have states that have sort of this mix. So the point at the end of the day is that, it's possible to do time tracking with either your own system that you build in-house or with a commercial system. Now, the things you want to consider, cost, and that's a huge concern. It's definitely worth shopping around, and the cost will have to balance with some other things like mobility, adaptability, compatibility, ease of use. A lot of these homegrown systems, if you have a great IT person, you can certainly build some decent time tracking software. If they're given the time and the resources and a very good IT person, you can do it fairly easily. Now, will it be as easy to use as something like Defender Data where they have full-time staff who have spent a lot of time really kind of fine-tuning this, and they work with public defender offices across the country? Well, maybe, maybe not, and that's something you need to really research. How good is your IT staff? Are they able to do this? Talk to the folks at Defender Data, talk to the folks at Justware, talk to your IT staff. See what this would really take to get something that, one, is cost-effective, but two, is easy to use and possibly mobile. A lot of public defenders like to be able to actually track their time on smartphones or on tablets. And that's something that you have definitely with Defender Data. I believe Justware has it as well. Increasingly, IT people in-house are able to do that, although it tends to be a little bit trickier, but something to keep in mind. So the next few slides I'm going to go through fairly quickly. I don't think you're going to be able to see too much of this. I just want to give you a quick idea of what some of these time tracking softwares look like. So this is Missouri's. They built theirs in-house. And again, basically you have drop-down menus and you can pull down and click on create a time log. And again, I don't want to get into too much detail on these. Your time tracking software is going to vary based on your commercial system or your in-house system. But I just want to give you some quick screenshots to give you an idea of kind of what they can look like. So this is an example of Defender data's fairly clean screen. Again, if you have a good IT person and with a decent amount of time and some resources, you may be able to replicate something like this. If you already have Defender data, talk to the folks there. You may be able to just turn this on and then talk to them about kind of tweaking it a little bit for a time study. And then this is Nashville. This is another homegrown system. So how long must defenders keep track of time? Well, the short answer is permanently for the rest of your careers. I mean, this is something that the public defenders have been an exception to this for years and years. And I know it's difficult in a lot of offices, and hopefully during the question and answer session we can address a little bit about ways to kind of overcome resistance to this. Because nobody wants to add, again, it's one more thing to do. And I think Tom alluded to this a little bit, that you know, public defenders, they're already doing a ton of work. They're already overworked. That's why we're doing these studies. You're asking them to do yet one more thing. And that's a difficult sell. And that goes back to yet another thing that Tom said, that the importance of educating your public defenders about data and how you're going to use it, why it's important. But again, the short answer, you have to do this permanently. And one, this is going to happen. You know, legislatures increasingly are starting to require public defenders and other assigned counsel to do this anyway. You know, it's much better to get out in front of this thing instead of having this dictated from above. As a public defender, get in front of it, start tracking it on your own. Then you can kind of set your terms. You can set how you're tracking this. You know, we're in the 21st century. It's going to happen at some point. But the other reason is that this has a very big effect on funders. You know, if you go, you know, Missouri, we did a workload study. When we went to the legislature, for the state legislature, and said, our public defenders statewide are tracking their time in fractions an hour, and they've committed to doing that for the rest of their professional careers. The first thing that the legislators said was, prosecutors aren't doing that, right? No, that's right. Prosecutors aren't doing that. One of your goals as a public defender is to be one of the most responsible, transparent agencies in your state, in your county. And this is one of the ways to do that. Now, for purposes of the workload studies that we've been doing, we then take 6 months of that data in order to get a decent sense of how public defenders are spending their time. So the short answer is, again, you're tracking it permanently, but we take 6 months of data for purposes of our studies. Now, before we start that 6-month clock running, however, a lot of times we give it a little bit of 3 or 4 months, sometimes a little bit longer, in order for public defenders to get up to speed. A lot of times this is very new. I think the transition with the younger attorneys tends to be a little bit easier because they're a little bit more tech savvy, but that's not always the case. Sometimes you have some older attorneys who definitely are as well. But in any case, a lot of times you have there's a little bit of a learning curve in terms of tracking time, just using the software, and also how do I fit this into my day, my already very busy day, and making sure that you have public defender compliance. So we have a little bit of a learning curve before you hit that 6-month period. So I'm going to move now to the Delphi process. Basically, the Delphi process, we're leaving the world of what is the time study behind right now. And we're moving on to the world of what should be, the Delphi process and workload standards. So this is completely separate from your attorney's tracking time. Basically, we want at the end of the day to figure out how much time should your attorney spend on cases, on average, in order to be reasonably effective, right? Well, you know, we can talk about maybe in the question and answers, but we've attempted this as public defenders for decades. In 1973, the NAC standards came about. There are a lot of problems with those, and maybe we'll talk about that a little bit. But we've been trying to get a good way to get a handle on what should be, what hours should attorneys be putting into cases. So the Delphi process seems to be the best so far. And this is something that we stood up for funding challenges in Missouri, and we're going to be using it in Rhode Island and Tennessee. But this is a way to show how much time they should be putting in, and this is through a multi-round survey. It is a technique that was developed by the RAND Corporation back in the 50s and 60s. It's been used by many businesses. It's been used by the military. So it's a tried and true technique to basically distill expert knowledge. So if you have a lot of experts on a topic, how do you take their collective knowledge and really kind of distill that down into some sort of number, right? So that's essentially what we're doing with the Delphi process. this is important. We're using the same case types and case tasks that we did with the time study. So you're tracking exactly the same sort of information. We need some sort of apples-to-apples comparison. If you broke down your case types like we did in Missouri, we had the 8 case types for the time study. You're going to use those exact same ones with the Delphi process, and same thing with the case tasks. And essentially, you're asking your expert panel, and again, your expert panel, we're taking state experts, and this is a mix of public defenders and private defense attorneys, generally people who've been practicing for 25 or 30 plus years in this area. And we're asking them some variation on the same question. And that question is, how much time, on average, is reasonably required to perform this case task, so for instance, in-person client communication, for this case type, for instance, homicide, with reasonable effectiveness? So you're asking some variation on all those questions. So in Missouri, again, we had 8 case types and we had 14 case tasks. If you multiply that out, that's 114, you know, if you think about it like a grid like this, case types and case tasks, you get 114 data points then. So it's a lot of questions, so you're asking a lot of your expert panel. Now, let me back up real quick. We do this, and it's an anonymous survey. So when they're doing this, they don't know what the other experts are answering for the first round. It's just a survey, and you know, and Tom had mentioned using SurveyMonkey. You can use something like that. Basically, any way to get the survey out in front of them to have them answer these questions. We then do, using the Delphi process, a second round. In the second round, you're asking the exact same questions. The only difference is that now you're giving them information that help aid them in terms of answering that question. So you're asking the exact same question, but you're also telling them, well, okay, when you're answering this, here was the range, right? Here was the range of answers, and maybe you're here in the middle, maybe you're way off to the side, but here's what the range was, and here's what the median was, right? And here's where you sit. Now, do you want to keep with your answer? Do you want to stick with it, or do you want to move a little bit based on what this range is from the other experts? So we give them a little bit of information. The final round that we do then is in person, and you actually get all these experts in a room, and we did this in Missouri, and we'll be doing this in Rhode Island and Tennessee, and they really duke it out. You know, you get a bunch of public defenders who have been doing this 20, 30 years and have very strong opinions about how much time you should be spending on a case. They really duke it out. But at the end of the day, we get answers. You know, we get these standards. And this is based not only on their experience as public defenders and private attorneys, but also we're giving them standards to work with. So we're giving them ABA defense function standards, providing defense services, the 10 principles. So they have something to go on. So based on these principles and based on your experience, how much time should be spent? Now, at the end of the day, this is what we ended up with in Missouri. So for the Delphi process, now this is how many hours should be put in order to deliver reasonably effective assistance of counsel according to prevailing professional norms. And this is just an average. So the Delphi panel in Missouri said, on average, you should be spending 106.6 hours on your murder or homicide case. You should be spending 47.6 hours on your AB felony cases. 25 hours on your CD felony cases. Now, again, this is everything from, they're covering all the hours that it takes to do research, all the hours for investigation, client communication, researching sentencing, and so forth. So I'm going to come back to these numbers in a minute, but remember, the workload studies have 2 portions. You have the time study, which is a measure of what is, and you have your Delphi process, which is a measure of what should be, your workload standards. Now, here's what happens when we compare those in Missouri. You know, again, this is the number of hours, if you look at the time study, that attorneys were putting in. If you look at the Delphi, this is the number of hours that experts through this rigorous process said that they should be putting in to be reasonably effective. Now, when you look at the top, there's a gap, right? You see in murder and homicide, there's a definite gap there. But as you go down, the gap gets much larger and larger as a percentage. So if you go down to misdemeanors, on average, these attorneys were spending 2.3 hours on a misdemeanor case. And again, you think about that, what kind of investigation can you do in 2.3 hours? What kind of legal research are you doing? How much time are you meeting with the client? How much time court time and all this, it's unbelievable that somebody really could be effective in all these cases in 2.3 hours. The Delphi panel said that it should be much closer to 12. Now, that's a huge leap. We're talking roughly five times the amount of time that was being spent. Now, again, that gap isn't as big when you go up to that murder and homicide level, and intuitively this makes sense, right? You have offices that are kind of triaging. If you have just a few murder cases, you're going to push especially if you have death penalty cases, you're going to push your resources to those death penalty cases. You're going to push your resources to those murder cases because those folks, the penalties are huge there. We're talking in some cases about somebody's life. So of course that the gap's not going to be as big in those areas. Because as a public defender, it would be irresponsible to not really push for resources and to really effectively represent somebody charged with a homicide. Now, unfortunately, and we see this, the NACDL had a great study a few years back, minor crimes, massive waste, that talked about misdemeanors. Now, you may have just a few people in those homicides, and of course you're going to push your resources there, but down at the bottom of this pyramid, you have a lot of people charged with these misdemeanors, many times more charged with misdemeanors than you do with these homicides. And a lot of times those are the ones being ignored, and that's exactly what we see here. So I'm going to go ahead and wrap it up. So that's the gist of the workload studies. And again, this is kind of a 30,000-foot view. And if anybody has any questions about this, don't ever hesitate to email me, give me a call. I know my number was on the front of this presentation. I'm happy to talk more about it and the studies we're doing, and we're happy to work in additional jurisdictions. We have a few more coming up. And I'll turn it back to Michelle for questions.
Thank you very much, Jeff. And I would like to remind all the attendees as well that if you would like to ask any questions, you can type some questions in at the bottom of the screen, and we will get to them, time permitting. And if there are additional questions, you can always reach out. You can see there on the screen Preeti Menon, who is the Senior Policy Associate at Justice Programs Office of American University. You can always email additional questions to her, and she will make sure that the panelists receive them and they'll be able to respond. So, Jeff, I do have a few questions for you. Thank you so very much for that presentation. I think, any opportunity to talk about the workload studies, which I think is very, important and groundbreaking work in a lot of ways in data collection and analysis for indigent defense. I think it's critically important, so thank you very much for that. I do have some questions about timekeeping to start, because these studies do involve those two parts. So have you heard about in terms of, defenders maybe, not all defenders, or maybe some defenders not wanting to track time or do timekeeping?
Sure, and this is common and it's understandable. You're asking already overworked defenders to do yet one more thing. And one more thing that, I think a lot of them see is kind of putting a microscope on them and their work. And also a lot of times learning new software, which, nobody wants to do, right? So this is something that we face, and it's, it does tend to be a little bit easier with newer defenders. You bring somebody new into the office, and frankly, they don't know any better. This is their reality. So if they come into the office and you say, welcome to the public defender office, we keep track of time, and here's how we do it, it's just one more training that they do. So with the younger attorneys generally, or newer attorneys, we tend not to have quite as much resistance, although it happens there too. A lot of the resistance tends to be attorneys who have been there for 5, 10, 15, 20, years. And again, that's not always the case either, though. There is some variation. At the end of the day, there are kind of two things that I think are important to keep in mind. One is going back to what Tom had said about educating them about the importance of data. Become a public defender. Did you become a public defender to be kind of a speed bump along the way to a guilty plea? Well, nobody does that. Nobody wants to do that. Did you become a public defender to be a part of assembly line justice? No, absolutely not. Nobody signed up for that. But in too many jurisdictions, we bend toward that. And I think seeing that larger picture, that a workload study like this and tracking your time can really help, tends to persuade, And in addition to that, though, at the end of the day, if you make it part of the job, it's part of the job, and you got to do it. And it's tough, and there's definitely a transition period, and that's why we build in a series of months for people to adjust to the software and complying to it. But if somebody just didn't file motions on a case, how would you address that? How would you, so there's kind of two pieces of this. One is doing that sell and convincing them of the importance of data, and it is important, and it can make a huge difference in your career and in your office. But two is ultimately, as a public defender, as a chief public defender, or as a supervisor, you have to ensure compliance. I mean, you have to work with defenders to educate them, but also say, look, this is part of your job, just like filing motions, just like visiting your client. You got to do it.
So following up on that question really quick, you talked about the resistance in software. And so did you or your teams look at other ways of collecting time, say through existing programs they already had, like payroll systems, because some of those actually, allow you to track time. There are some, cost-efficient apps that help people track time that way. Did you look at alternatives to, more customized software for offices?
Yeah, we've looked into it, and we're kind of constrained by a couple things. The main thing is that whatever it is, it has to be able to track time according to both case type and case task. If it can do those two, and it can track time in fractions of an hour, and usually we recommend about 10 or 15 minutes for the minimum time, but offices have done 6 minutes, 7 minutes. As long as it can do those things, and you can extract the data once you have had all these folks track time, that works. That should be fine.
Great. We have a question from one of the attendees, and I'll read that to you, from Catherine Johnson. The question is, a criticism to the Delphi process is that when it's done by public defense attorneys, it's self-serving and subjective. Any advice on whether to include other partners, prosecutors, judges, private bar, to insert more objectivity into the process?
Yeah, that's a great question, and that's something that we're definitely trying to refine and do more of it, build in more neutrality and objectivity. Again, our goal at the end of the day is to be the clearest, most transparent, most responsible agency in your jurisdiction, right? So how do you do that then? And we don't want allegations of just kind of cherry-picking defenders. Frankly, I think when you look at most jurisdictions, if you practice in an area, in a state or a county for a significant amount of time, and you ask the judges, you ask the prosecutors, who are the top defense attorneys here? Generally, people are going to agree. I think generally folks have a fairly good sense of who those true experts are. But having said that, one of the things that we're working on now in both Rhode Island and Tennessee is they have kind of, and we're toying with the terminology of this, kind of the super luminaries or kind of a selection panel, where basically you have people who, again, they have to have some sort of experience with defense, because defense is definitely a different activity from prosecution. They're not, I know there's a lot more similarity in some civil areas, but in criminal areas, I think that the duties are fairly different. So you have to have somebody both in the selection panel and the ultimately expert panel who does have some familiarity with what goes into public defense. But if you can get, say, 3 or 5 folks on a selection panel who are, say, people who have done private defense. A lot of judges, you've served as prosecutors, and then later on did some private practice as criminal defense attorneys, and now they're on the bench. And if they're a very respectable judge, somebody that you can work with, and somebody who you can definitely rely on, and it's a great person to include in kind of that selection panel. So then that panel can select, anywhere from we aim for roughly 40 people for a state in order to on that expert panel. Usually roughly half and half public defenders and private defense attorneys. So again, that kind of selection panel, it adds a little bit of an extra layer of objectivity. Another thing we do is we always have an outside agency working with us on these Delphi processes. So it's not just the public defender saying, here's what those numbers are. We have, in Missouri, we had an accounting firm that we worked with, Reuben Brown, which they were fantastic. We're working with Crosland and Associates in Tennessee, another accounting firm, and Bloom Shapiro in Rhode Island. But also, you know, Tom, I think you had mentioned, and Michelle, you had mentioned working with academia too. The Texas Workload study, they worked with Dottie Carmichael at Texas A&M. So those are a couple ways to build in some objectivity to the Delphi process. And we're working on additional ways to refine it, though, too.
I think with the Delphi process and the timekeeping, I think on both ends, you also may have, on the one hand, with the timekeeping, people may be overestimating how much time they spend on certain cases for, you know, for one, just subconsciously for fear of thinking, wow, I should be spending more time on this, and maybe I do, but in reality, they actually spend less time. And then with the experts, on the other hand, because they are experts, they may report the amount of time that they think should be spent on a particular case, but in actuality, with somebody with less experience, it could be more time. So I see the numbers that you put up with regards to the comparison with the time study versus Delphi, where actually, although we see these stark differences, the differences could even be starker given those human tendencies.
I think that's absolutely right. I mean, I think at the end of the day, this is a good conservative estimate that, you know, not just an estimate, that's the wrong word. I mean, this is really a pretty finely tuned thing, but even then, you're going to have human error. And that's the truth of, you know, whatever you're going to do in this area. But part of that is going back to training before we do that 6-month time study, is really training these line defenders, you know, exactly how we want them to track time. And we want them to be as accurate as possible. And a lot of times, you know, you're talking about human error, a lot of this is the law of large numbers. You know, you're not just looking at one attorney in their time, but you're looking system-wide. And if you start to see big outliers, you know, so-and-so says that they're spending, you know, whatever, 10 hours at the jail when everybody else is only spending 5 or 4, you know, you have an outlier, and then you need to do a little bit of research and see, well, why is that? Are they genuinely spending that much time? Is it, you know, and why is that? Or is it there a mistake in terms of time tracking? So again, that's why we have that learning period before we jump into the 6-month study. The Delphi process, the Delphi process is a little bit tricky because you're not you want workload standards, right? We're not dealing with what is reality. We're dealing with what absolutely should be in order to be effective. And you know, the Delphi process is very rigorous, and it's been used in businesses and academia and the military. But yeah, and again, you rely in part on the law of large numbers. So you may have some outliers in terms of these numbers, but basically, when you have 40 experts and you have hundreds of years of experience, you know, and you're distilling all that knowledge into these numbers, you should have a pretty accurate sense of how much time should be spent.
Okay, great. Thank you. Thank you. I want to also thank Catherine, and I hope we answered your question. But I wanted to let everybody know that after the webinar that PowerPoints will be available and also available at the righttocounselta.org website. Jeff, I wanted to ask you the same question that I asked Tom in terms of getting up to speed on this. I know that your background is, you know, you're, you know, criminal appellate attorney. Did you have a large statistical background that enabled you to get up to speed on this, or how difficult was it for you?
Well, I had, you know, my dirty secret is that I went to grad school before law school and was once upon a time going to be a sociologist. So I have a master's degree in sociology, and so I do have a little bit of background in this before I came into it. But frankly, that had been years and years. You know, I'd gone to law school and practiced as an attorney, both at a firm and as a public defender, before coming here and working on workload studies. So there was a little bit of a learning curve, and I think having somebody, you know, I mean, Margaret Gresson's in Tom's office, Andy Davies in New York, a lot of these offices do have some IT folks in-house, which is fantastic, but a lot of people don't. It's a little bit tricky to get up to speed, but it's definitely possible. I think it's something that attorneys can learn and should learn. And if you ever need, if you're just interested in statistics generally and how some of these numbers work and the law of large numbers and things like that, there's a great book called Naked Statistics that just really breaks it down. It's very simple, great for lay people. So if you want to kind of get up to speed on basic statistical and basic kind of big data stuff, great place to start.
Great. I do have a question for both of you. I believe both of you touched on this. And the question is, what are some of the incentives that you have used to encourage people to submit data, submit the information? Because like you said, people are very busy. It's hard enough to do the work itself without having to say, okay, let me input this information. How have you incentivized or made it easier for people to do that? And this question is for both of you.
Yeah, I'll say, this is Tom, that for us, it's worked best when the work relates, they can see an incentive. So for example, for the Private Sign Counsel, they understood that the research we were doing and the report we were doing was directly related to increasing their resources. So we didn't really have to pitch it. I think if we had not turned around and produced a report, we would have lost credibility the next time we wanted to do that. We've never been in a position where we've had to kind of give outside incentive, you know, do a survey and win an iPad type stuff. And I think as a state agency, it'd be very hard for us to do that. So we do our best to educate people that the data is going to be used, and it's going to be used in a way that will have at least a reasonably direct impact on their work and what they're doing for their clients.
Great.
Yeah, my answer is fairly similar to Tom's. That we've never used incentives. And part of that is just, you know, it's cost prohibitive, I think, for a lot of offices. But in addition to that, we're asking people to track time permanently. So if you take away those incentives at some point, do they stop tracking time? Do they, you know, we didn't want to get into that mess. You know, a lot of it is kind of, as Tom was saying, just educating about why we're doing this and what this can be used for. And in the case of workload studies, again, it can be used for both working with the legislature or your funding source to get additional funding, but also it can be used for case management within the office and managing attorney caseloads within the office. I think educating attorneys on that is the first thing you want to do. And then, you know, the incentives, we haven't messed with that at all. You know, I think something that both in terms of the learning curve and in terms of an additional time component, I think, you know, when DNA kind of first hit the scene with public defenders and all of a sudden everybody has to learn a little bit more about forensics, things that they hadn't studied in high school, again, you're asking them, attorneys to do a lot more. You know, you're asking them to learn about science, which is, you know, for a lot of attorneys, they avoided med school for that very reason, and here it is, you know, forensics, it's right. You're asking them that, you know, it's more time, but, you know, most agencies, you didn't start giving incentives. You said, this is part of your job now, you know, and it's tough, and it's a learning curve, but here's why we're doing it. You know, we're doing this for the clients, and that's the exact same thing with these workload studies.
I like the similarities in both of your answers in terms of not only educating people as to why you're doing it, but that's a very good starting point before you even start collecting data, because I think you have to know what the end game is, what your goal is, before you know what type of data to collect, correct?
Yes, I mean, I think, for example, if you're doing a survey monkey, you need to sit down and think, what is this data going to be? How am I going to organize it? What am I trying to gather, and what will my end product be? Or you may end up with a lot of data that you're not able to really use or organize. So you always have to have kind of, you know, your eye on the prize of what are we expecting to learn, what are we expecting the deliverable to be for all the work you're doing.
Exactly, exactly. And Jeff, you made a very good point about you can have too many data points, which basically just neutralizes or waters down anything that you're trying to do. And I think that's something certainly that we should all keep in mind when we're trying to collect and analyze data.
Yeah, and I think that's absolutely, you put it in a good way. It's almost like maps in a sense. You could have a map as big as the territory if you wanted. We could have a map of Illinois that's as large as Illinois, but it's not usable. Or on the opposite extreme, you could have one that's very tiny and doesn't show too much. You really have to strike a balance where you have enough data. It's not too much data, not too little, and has a pretty accurate picture of what you're doing. And it's a tricky balance to strike.
Great. Well, I do want to thank both of you very, very, very much. It's been not just informative, but I think it's been a very energizing and very inspirational conversation. It's one of those for many of us, uncharted territories that I'm, hoping that more and more offices will look to and realize how much data they're already collecting and take it from there. There is one thing I would like to push in furtherance of our embarking on this journey together, which is this basic data toolkit. It's a basic data every Defender program needs to track. This is a toolkit that was produced by NLADA, Maria Beeman, our Director of Justice Systems Evaluation and Research Initiative, wrote in late 2014. There will be a link to the toolkit on the righttocounselta.org website, but also I say check it out because it is a good basic start for folk in terms of, for example, what types of categories, you could start collecting. And this is a lot of work that was done with Tom's office and others in terms of helping to discern what those data points are and what those starting data points are that a lot of people are already collecting. And it's a basic toolkit to help walk you through how to start collecting and analyzing data in a very targeted and concerted way. We also hope to have a link on the same website to Tom's private assigned counsel survey that can give people an example of how to use, say, SurveyMonkey, for an example, to package it in the data in such a way to be effective and persuasive. The Missouri Workload project, is that online as well, Jeff?
It is, yeah. If you go to indigentdefense.org, indigentdefense.org, and it's on the website.
And we'll try to put a link up to that as well so people can look at that report in more detail and see how that Delphi process worked for Missouri and look at it and see how it might work for you. Again, thank you so very much for attending the webinar. We do have a third webinar scheduled for July 30th, and that's session 3 on persuasive budget advocacy. We've talked about cultivating relationships with other stakeholders and also within the Defender community in the session 1. And today we've talked about data collection and analysis and begin to have a conversation about how to use that data. And then in the third session, we will focus more on the advocacy portion of that. Once you have that data analyzed and you know where you want to sell, how do you sell this information to get what you want in your budget advocacy? So join us on July 30th at 2 p.m. And I hope to see you then. Meanwhile, you can always check us out at the website, www.righttocounselta.org. Thank you so very much.
Thank you, Michelle.
Thank you.